Hi, hello everybody. I will let everyone in first before we start. Hi everyone, we just wait a couple of minutes. Few other people are coming in. Okay. So good afternoon, and thank you for joining our webinar on running your business in Singapore. I am Clémence, the advocacy manager at EuroCham Singapore, and I really appreciate your presence at this exciting event, especially given the recent release of Singapore's budget 24. As some of you already know, the government has introduced a new tax credit, RIC, aimed at supporting high value and substantive economic activities in key sectors and new growth area. But before we delve into the discussion, I wanted to express my gratitude to our partner, the Southeast Asia IP SME Helpdesk, because this event has been crafted in collaboration with them. It's an initiative funded by the EU that provides free intellectual property advice for European SMEs operating in Southeast Asia. They offer confidential IP advice, they raise awareness about IP matters affecting European SMEs in Southeast Asia, and they also help make inform IP decision. But now, without further ado, let me introduce you our moderator today, who will provide the opening remarks. So Max Ng is the managing director of Gateway Law Corporation. So thank you, Max. And he oversees Gateway Singapore offices and specialize in licensing, franchising, fintech, data protection, and privacy. And obviously, he holds a prestigious position, various, including being the fellow with the Singapore Institute of Arbiters and the Asian Institute of Alternative Dispute Resolution. But now I will turn it over to you, Max. So thank you very much.
Thank you very much, Clemence. I'm very, very happy to see that there's such a diverse crowd of people attending and such strong interest as well from the attendees for today's event. All of us have come together to learn from the experts in the various fields who are going to be most generous with their time today in sharing the latest news and information that I'm sure will help you in running your business in Singapore. Our speakers today will take you through several of these different aspects when it comes to running your company in Singapore. Our first speaker is Quentin, who will be presenting largely on how companies enter the Singapore market. Quentin will be, he's the manager of the customer success team at Sleek, which is a corporate secretarial service based in Singapore, and I believe also has offices in Hong Kong. And Sleek assists companies in managing their finances and starting their businesses here, and also offers additional services such as GST registration and filing of companies' corporate returns. Quentin, I believe, has worked at Sleek for 3 years, for which time he rose to his current position. And before joining Sleek, Quentin was a marketing executive with the European asset manager Amundi. He has been in Singapore for 5 years and holds a Master's of Economics from Bhutan University and a Master's in International Business from ESSCA. Quentin will help the participants today in terms of choosing the right business structures and discuss the essential steps for compliance. After Quentin speaks today, we have Jevon. Jevon's from the prestigious firm of Shuklin and Bock in Singapore, and Jevon heads the intellectual property technology and data practice. Today, Jevon is the external expert speaker appointed by the Southeast Asia IP SME Helpdesk, to which we are very grateful for co-organizing this session. Jevon's experience extends to both contentious, non-contentious matters across multiple industries, including pharmaceuticals, renewable energy, manufacturing, constructions, logistics, and semiconductors. On the contentious side, Jevon has represented clients in court proceedings as well as in alternative dispute resolution proceedings. He also specializes in IP litigation and has conducted disputes before all levels, IPRs, registry, high court, even the Court of Appeal in Singapore. So I think we can all say that Jevon is very well suited and certainly more than competent to present today. Jevon will speak to us today about intangible assets and understanding the importance of IP audits and strategically registering your intellectual property rights. And lastly, but certainly by no means least, is Marta, who will be sharing with us about the human resources aspects in terms of running a company in Singapore. Marta is the managing director of Fidinam Singapore. Fidinam is a private consulting firm founded in Switzerland in 1960. That's quite a long time ago. It offers tax, business, real estate, and digital consulting services to companies, entrepreneurs, and individuals, and operates in many countries worldwide. Marta was appointed to her current position in 2021, and she has more than 15 years of experience in the industry. Marta graduated in Business Management and Administration from the Catholic University of the Sacred Heart in Milan, and she's also a professional chartered accountant. So today, Marta's focus will be speaking to us about the Singapore human resource and immigration landscape. So if you have any questions, please do feel free to put them into the chat box, and there's a Q&A, I think, panel as well, from which we will be reading and taking questions, which you can put to the speakers, and we'll take them as the session goes on. So without too much further ado, please, I will now turn the floor over to Quentin. Thank you, everybody, for your time.
Thank you, Max, for the introduction. Nice to meet everyone, and happy to see that so many attended for this event. So let me start sharing my screen, and from there, then we can start the presentation. I believe all good. Everybody can see my screen, right?
Yes.
Okay, perfect. Okay, so maybe today my part, I will try to cover basically two very quite simple but basic and very important topics about firstly starting the company in Singapore. What are the requirements? What are the things to have in mind? And then I will also tackle regarding the part meaning how to keep the company compliant, mainly focusing on the requirement from ACRA and from IRS side, so that every people here can have a clear understanding about what it means to start a company and how to do it. And firstly, once the company is set up, what are the ongoing requirements yearly to keep the company running in Singapore. So to start clear now with like the requirements, make sure everybody has them in mind. To starting a business in Singapore is really straightforward. To start a private limited company, which is the most common type of company set up here in this country, you will need to have 5 things to start a business. So first thing, of course, you need to have at least one shareholder, who could be an individual or a company, and can be based in Singapore or overseas. So there's no requirement to have any kind of local shareholder. On the contrary, though, regarding directorship, you will need to have at least one local resident director based in Singapore, and then you can have as many foreign directors as you wish registered in the company. So by local director, we mean that person needs to be either Singaporean, either PR, or under certain work paths, some person can also be considered local director. For example, one pass holder, entry pass holder, an EP holder will be considered local director of the company as well. Thirdly, regarding the capital, the barriers to entry is quite small. Like it's possible to register a company with only $1 Singapore of capital, and which of course can be upgraded at any point of time. Then fourth requirement is to have a local secretary in Singapore, who is basically the person in charge of looking after the compliance of the company. And lastly, you also need to have an address where the company will be officially registered at, where basically all the local authorities, should be IPRs, ACRA, usually also the banks as well, will basically sending a kind of letter to address to your business, basically. So really that's the 5 like quite easy items you need to have in mind if you wish to like set up a private limited company in Singapore. Now regarding foreigner, especially for company based outside of Singapore, among those 2 criteria we see above are 2 which may be challenging. The one is to have a local director, and second one is to have an address for the business. So especially for foreigners, there are basically options to make sure that you fulfill those requirements. In Singapore, it's quite common for corporate secretary and other potential service provider to offer what's called nominee director services, meaning that we'll be able to provide a local director for the business without needing to actually either have a business partner living in Singapore involved in the company, or until, for example, one of the foreigners move to Singapore under a work pass, which allows them to be the local director of the business. One thing to have in mind, though, is that in general, a nominee director will not hold any legal or regulatory responsibilities. Will hold only legal and regulatory responsibilities, and they are not involved in the operation of the business. So the main goal is for sure, because you do not want a director that you hire from a corporate secretary provider, for example, to be involved in contract or any kind of operational dealing. So like the idea is that the foreign directors will always be the one who keep full control over the commercial activity and the business. And the nominee director is only here basically to make sure that the company follows the regulation, which is so to have a local director in the business. Second thing, of course, it's completely possible then to hire actually a registered address, which will be the official address of the company in Singapore. So there are multiple service providers for it, but that's something that to have in mind. And one thing also, second thing I would have to highlight is that if you were to be running a company from abroad and just open a company in Singapore as a holding company at the beginning, or just operating even company fully from abroad, I recommend to have a service to make sure that like every kind of letter sent to the registered address is either forwarded to you or uploaded online on a drive, so that you make sure like even if you manage completely your company from abroad, you always have access to any kind of communications sent from ACRA, sent from IRS, or sent from the MOM to your company. And lastly, like especially also for foreigners, if you wish to relocate to a company you have open in Singapore, so it's possible indeed to apply for a visa to make sure you can work for the Singaporean company. Other thing to have in mind when starting the business, so here is like non-exhaustive list, but just other thing to have in mind. Of course, name of company is quite important. Some names are prohibited because these are like regulation prohibits for using them, or just because they're already taken. Second thing, of course, it's really important to have in mind the nature of the business, because depending on the company nature, you may or may not need a license. So how ACRA will see the nature of the company is based on what they call SSIC codes, which basically classify the nature of what the company is doing. So each company can have up to 2 SSIC codes, which you can change during the life of the company. But so like what I really want to highlight is, so depending on the SSIC code that you choose, you may need some licenses to operate. Typically, if you are in the financial industry, if you are recruitment agencies, if you are maybe in cybersecurity or in biotech, you choose then the code accordingly to those activities. This means that you also need to get a license separately to operate your business here. Third thing also to have in mind is also to choose your business, choose or at least have in mind what is your financial year. in Singapore, there is no fixed financial year, meaning that you can decide what is actually the end of your financial year. Knowing that, like by default, of course, the financial year is 12 months. The reason why it's really important to at least know your financial year is because, and then I will speak about it later, but basically all your tax filing, all your compliance dates actually depends on the end of your financial year. So it's really just really important to have this financial year in mind, because all your tax filing will actually depend on its end of the financial year. Again, also like there are multiple options for corporate bank account opening in Singapore. So depending on the end of your business, like different banks or fintechs will offer different kind of services, but it's good to think about it beforehand, especially if you deal with countries who sometimes are not maybe the easiest country to deal with in terms of banking. For example, to send usually money to Vietnam or to India or to China, some fintechs will not always be able to do it. And second, also, if you use a more traditional bank to deal with those countries, the fees will not be the same as what other fintechs could be allowed. So that's also some consideration to have regarding corporate bank accounts. For the office location, basically, here I would say it's kind of related to the business address I mentioned at the beginning. So of course, having like a registered address in the CDB in Singapore can enhance your credibility. But that's also something you have to keep in mind. Some industry also will have a need for specific insurances. And so that's like, again, that's also actually related to the SSSC code of the company and the need for licenses. Lastly, you may also need to, when you set the company, to amend the constitution provided by ACRA if you would like to, for example, create specific class of share classes. So depending on how mature your business is and what are the needs, you may need to further amend the basic paperwork provided by ACRA when you actually register a business. And license and permits, so I already touched base on this a bit. But basically, so those license and permits are basically related to the SSC code you choose for your business. So that were basically the most and the key information to have in mind to start a company. Now we'll just review like all the different important things you need to have in mind to keep the company compliant year on year while operating the business. So in terms of important notes and 3 things to really keep in mind, that the Singaporean entities must adhere to every kind of reporting standards set by ACRA and IPRs. So ACRA is a Singaporean government body in charge basically of company registration, and IPRs is a tax authority. If you fail to meet any kind of requirements, that would lead to fines and potential penalties as well. And again, as I mentioned previously, all the key dates for reporting are actually triggered by the end of your financial year. So actually, to give actually an example of what are those timelines, here's an example for a company which would have been incorporated in January 2023. So by default, this company will have a financial year of 12 months, meaning that its financial year will be ending in December 23. And from there, which is towards the end of the financial year, all the compliance basically will be triggered by this end of the financial year. On the top of the arrow, you basically see the 2 financial years, which are the 2 deadlines, which are actually due to the tax office, so to IPRs. So 3 months after the end of the financial year, you need to submit your estimated chargeable income to IPRs, which is basically an estimation of the profits you are going to pay for the profit made during the previous financial year. And then in November of the same year, then you'll file the final corporate tax return, which IPRs call either Form CS or Form C, which is actually the final time when you pay your taxes. If you had overpaid in March compared to November, IPRs will give you a tax credit. And if you had underpaid, well, then you pay the balance. And then on the lower part of the screen, so the 2 deadlines for June 24 and July 24, those are the deadlines related to ACRA. So basically 3 months after the ETI, which is actually more 6 months after the end of the financial year, it's mandatory to have held the annual general meeting of the business. And actually, first my bad is actually a mistake on the slide. 1 month after the AGM, then it's mandatory to file the annual return. The annual return being basically the financial statements signed during the AGM, which needs to be sent for ACRA for recording, basically. And now when I do more, maybe a bit more about the details about how to take care of those different filings and so to ensure the compliance of the company. So usually it would be the role of the company secretary to take care of all the filing with ACRA. So corporate secretary would support the regulatory needs of the company by preparing and filing the annual return of the company, by holding the AGM, and doing the life of the company by basically taking care of any changes regarding the structure of the business. Meaning if you need to appoint or resign directors, corporate secretary, auditors, if you need to change also the person in particular because they have moved to a different country, if you need to distribute dividends, if you need to issue new shares, track of the company, or basically anything related to the structure of the business and related to ACRA, basically. So that's something the company secretary would be in charge of. On the other side, if you were to hire like a tax agent and accountant, so that's the kind of person who will be in charge of the ECI I mentioned before, tax return as well, which is from C or from CS. They will also be the one preparing the financial statements, which are required for the AGM. And if applicable, they will also be able to work on the GST as well, and potentially also support payroll, payslip, and also kind of like government contribution and needs to be done for employees in Singapore. To give you an idea also of the consequences of like not meeting basically or like missing deadlines for filing of AGM or annual return. So that's a late penalty fee provided by ACRA, which can be found on ACRA website. Basically, just for missing the deadline of the AGM, that's like a lump sum penalty of $300. And for the annual return, it's also $300 if you're late for the first 3 months. But if you're actually late for more than 6 months for filing the annual return, more than 3 months, so not more than 6 months, you have another $300 penalty. So being like late for more than 3 months for the AGM and annual return actually leads to a penalty of 900 Singapore dollar automatically. And from experience, ACRA is not always the easiest to deal with if you want to get those fine money back. Now touching base also on other topic, which quite important to understand in terms of like the tax filing and the deadline I mentioned before, is actually what is actually the tax system in Singapore for corporate tax on profits. So I would say in Singapore, like the tax system is quite straightforward. The general tax rate is 17% on profits. Now, actually, every company is, except holding companies or other exemptions, the big majority of the company will always be eligible for what is called here on the right side of the screen, the partial tax exemption. Meaning for company, they will only pay 17% on corporate tax on profit of more than 200K Singapore dollar. If the profit of the company are less than 200K, then it might be actually, the tax rate will be 4.25 on the first 10,000, and then from 10,000 to 200,000 will be 8.5K. And for companies who are younger than 3 years, so the first 3 financial years of the company, and who meets the startup tax exemption scheme and the conditions which are above, then actually like the tax rates are actually even more interesting, because the first 100,000 will tax at 4.25 compared to first 10,000 when the company is more than 3 years old, basically. Then so first 100,000 tax at 4.25%, then from 100 to 200, 8.5. And lastly, if the company has more than 200,000, here the tax rate is still 17%, which is the standard tax rate. So basically, the key main takeaway here is that for newly startup companies, it's possible, based on eligibility for startup exemption, to benefit from even reduced tax rates compared to like the normal ongoing fees of the year. But even after those 3 years, or if you do not meet the criteria for the startup exemption, the tax rate, maximum tax rate on profit is still 17%. And you have basically like lower tax rate up to 200,000 Singapore dollar of profits. And actually that would be it for my presentation. So I think I can give the floor back to Max to move on to the next presentation.
Sorry, thank you, Quentin. There was one question from from a participant, you may want to take a look at it. If this is something you want to answer now, or we can take a look at deal with it at the end of the presentations. That's also fine, Quentin. All right.
Yeah, maybe okay. Let me maybe at the end of the presentation, just let me the time to read through the whole question then.
I think let's move on to Jevon then.
Yeah.
Thank you. Over to you, Jevon.
Thank you, Max. I'm just going to get right into my presentation. Max has already done a very generous introduction of me, and can read my profile subsequently when the slides are distributed. So I'm here as a representative of the Southeast Asia IP SME Helpdesk as well. And the Southeast Asia Helpdesk is an initiative by the European Commission, which provides free, confidential, business-focused advice to small, medium enterprises and intermediaries in the European Union and other countries of the Single Market Programme, the SMP. So, for example, Norway, Iceland, Liechtenstein, Ukraine, etc. And it relates to intellectual property rights in Southeast Asia. On this slide, you can see the wide range of services offered by the Helpdesk. So firstly, through the inquiry helpline, you can send any IP questions related to Southeast Asia to the Helpdesk, and you can expect to receive a reply within 3 working days. Secondly, the Helpdesk organizes monthly training workshops and live webinars, which is tailored to the needs of SMEs across Europe and Southeast Asia throughout the year. So feel free to subscribe to its newsletter and connect with the team on social media to keep yourself updated on the upcoming activities. The Helpdesk website also gives you access to a wide range of publications in terms of country fact sheets, industry-specific IP guides, or general IP guides on various topics. These guides can be easily found on the Helpdesk's website as well. Last but not least, the Helpdesk also offers interactive learning tools. For example, there are e-learning modules which are available for download from the official website. So moving on to the topic that I'm here to present, which is the intangible assets. We're going to start off with an introduction to intangible assets. We'll then go on to discuss understanding the importance of conducting an intangible asset audit. We'll then talk about strategic registration of intellectual property rights. And finally, we'll look at registering IP rights in Singapore. Sorry, just having a bit of technical difficulties. Okay, so starting off with intangible assets. In 1975, tangible assets accounted for 80% of a company's value. So intangible assets accounted for less than 20%. By 2015, intangible assets accounted for more than 80%, right? This is from a survey in 2015. 2016, we start to see a host of technological themes. We have decentralization, AI, blockchain, and data, right? Cloud as well. And by 2020, despite COVID, now intangible assets account for 90% of a company on the S&P 500's market value, right? So there's a misconception that intangible assets or intangibles are just intellectual property, but actually there are a lot more. But to put it into some context for us, because sometimes it's easier to understand it this way, the intangible assets, these are two types of companies. On your right, you have companies that are your typical brick and mortar companies. So they're very familiar to you. Starbucks, for example, Samuel Adams, Whirlpool, Harley Davidson. On your left, you have your YouTube, X, formerly known as Twitter, and Evernote and PayPal. Now, the number of years that's listed there, as you can see, that's the number of years it took them to reach a $1 billion market capitalization. So you can see the stark difference between the brick and mortar companies as well as the companies that rely heavily on intangible assets. Intangible assets can be broken up. There are many ways to skin a cat, as they say. And something that's of more recently, this is one way in which people have put forward how intangible assets can be grouped. So we have a technology category, intellectual property category, and what we call business and operations category. Under technology, you have several. I'm just going to highlight a few. We have blockchain, NFTs, crypto assets. You also have artificial intelligence and machine learning. This is in addition to the other types of web content, website, and domain names, which all form that type of intangible asset class. Intellectual property, of course, you're probably more familiar with it. You have your copyright, patents, product designs, trade secrets, and confidential information. And the final category, business and operations, you have goodwill, know-how, human capital, and more recently, what we're seeing in our practice, more and more companies are trying to get into ESG attributes and certifications, right? So that can also be part of your intangible assets. So as you can see from this, the examples provided here, intangible assets are really a lot more than just your intellectual property, right? And all companies, all businesses have intangible assets. So keeping in mind what intangible assets are, we then move on to the intangible asset audit, right? So why do I need an intangible asset audit? You have financial statements, but these typically do not actually set out the intangible assets that a company has. The financial statement at most may include what we call goodwill, right? You're familiar with that. There's be an item called goodwill there, and there's a value ascribed to it. So intangibles are not being disclosed or in any meaningful way, and when they're not meaningfully disclosed and understood, they can't be managed. So most businesses can't answer these basic questions, right? What are my intangibles? Why do I have them? What am I using them for? And then how am I managing them, right? How can I better use or deploy them? These are actually very basic questions, but many businesses, are not able to actually answer them because they're not aware of what intangibles they have in the first place. So an IA audit, right, intangible asset audit, is a systematic review to help an organization identify its intangibles, understand how they are being used, and manage the intangibles and the risks that are associated with it. Diagrammatically, I found that this is quite helpful. So you have a intangible asset strategy at the core of it, and from there you have to identify your intangible assets, how are they being used, and how they're being managed. So as I mentioned, the top three hexagons relate to the intangible asset audit, but that leads to the bottom three, because once you identify and you know what assets you have and how they're being used, and you can then put in place strategies to manage them. Once you've accomplished that, you can then value your intangible assets. If you can ascribe a value to them, you can then insure them against risk, right? And then leveraging on them, has security to unlock more financing. That's also something that can be done. So at the core of it is having a strategy, and it's important to start off with the intangible asset audit, because that gives you an idea of what you have, which then can lead to the rest. So when we talk about identification, right, you can't manage what you don't know. That's why identification is the starting point, and it's very important. You identify what you have, what assets you have, how are they being used. You identify whether these assets are encumbered, right? By encumbered, perhaps maybe they have co-owners, so you're not free to simply use it on your own. You have to actually have, there's another owner who owns it. Perhaps that could be an encumbrance on your freedom to use this intangible asset. And of course, there's a scope of protection. Now, having a broad scope of protection or a narrow scope of protection, that's very important to understand, so that you can then decide how to exploit an asset. So that starts off with your identification. Then you go to use, right? How is it being used? Is this asset being licensed in, licensed out? Are we using it for collaborative purposes, right? And then do we want to use it, or can we use it for IP enforcement? So there are different types of IP enforcement can be with customs, right? For if you have a trademark, you can possibly use it together with Singapore customs to prevent goods from being imported into Singapore. You can have civil litigation where you have IP disputes being consolidated in the High Court. There's criminal prosecution by the states for counterfeit goods. We read about that sometimes in the media. And of course, you have what we call alternative dispute resolution, where you can enforce your IP rights through arbitration, mediation, or expert determination. Now, managing your intangible assets is also a very important part, but there are also inherent risks. You need to have adequate protection, right? To ensure adequate protection, that's one way of managing it, but also ensuring that you pay the renewal fees, because most registered IP rights require annual or perhaps every 10 years a renewal fee to be paid, right? And through management, that's how you also mitigate the risk to your intangibles. You want to prevent loss, misappropriation, infringement by third parties, and to ensure that you have proper title and ownership over your IP. All this falls under management. Now, recently in Singapore, we have the Intangibles Disclosure Framework that was announced. So these are the principles for businesses to disclose the intangibles that they have. So we have 4 verticals, and they have this nice acronym called SIM, where it stands for strategy, identification, measurement, and management. So it's very similar to what we covered just in the earlier slides. And the objective of the IDF is to give a standardized framework in which businesses can present their intangibles. So that helps if you're fundraising and you're presenting your intangibles in a particular organized format following the SIM framework or IDF framework, then that helps potential investors to understand, evaluate your business, and then that can actually lead to perhaps higher valuations, right? Which is something that would be very helpful. So I've provided the link at the bottom of the slide. Do go in to have a look. Now we're moving on to the final, second last actually, topic of my talk, which is the strategic registration of intellectual property rights. So you have the common ones such as patents, trademarks, and designs. That's what businesses rely on. But not all IP rights can be registered. So bear that in mind. Copyright, confidential information, and like trade secrets, that's not registrable. And if you have intangible asset audit satisfactorily concluded, you would understand where your intangibles lie, what's registered, what's not registered. Is there any intellectual property that should be registered but isn't presently so? So those gaps can be identified, and then a strategy can be formulated on how to address those gaps. So it's very common for clients to come to us to say that, I want to file a patent, I want to file a trademark, but we want to think and encourage our clients to think beyond just individual IP rights, but to have this concept of what we call a bundle of IP rights. And I think the best example of that I've seen is Apple, your iPhone, right? That we have your patents. An iPhone has approximately 500 patents covering it, and a lot of those patents relate to the licensing of 3G, 4G, 5G standards. We have trademarks. There are approximately 20 registered and unregistered trademarks just used in connection. So you have Apple that's there. You also have iPhone, that's another trademark. But even the software itself, a lot of the software apps that you have are trademarked. Also, the names of the software apps are trademarked. Some may be registered, some are unregistered. And finally, you have registered design. So the aesthetic look and feel, graphical user interfaces, there have been more than 20 granted. So it isn't one single IP right that covers the iPhone, but this rather large bundle that we've just seen here, right? And that's the kind of strategy that we encourage businesses to consider, a bundle of IP rights. So the best protection, as I said, not necessarily one IP right, but then at the same time, on the other end, you don't file for everything, okay? These are various questions that you should consider when you're considering whether or not to pursue IP registration, right? What are the intangibles that drive my market share and profit margins? Which IP right is suitable and why, right? So does the IP right confer a competitive advantage, right? What is that X factor perhaps that it gives? You know, what is the commercial lifespan of the product versus how long it takes me to get an IP right? So if you're going to pursue a patent, but you think the life cycle of your product is very short, and it takes 3 or 4 years to get a patent, your product, maybe it's 2 years, 3 years before the next iteration comes along, would it be worthwhile to pursue a patent, right? That's a question, it's a live question that should be considered. Branding and trademark strategy, that's very important. Patents tend to drop in value over time, but branding and the trademark value of your trademarks do grow over time because the trademark can last indefinitely in theory, right? Understanding your intangibles, how much are they worth, right? So it's always a cost benefit, because if your intangibles have a certain value, then you can then consider, okay, is it worth spending money to protect it? Right? If it has a very low value, the cost to protect it may not be worth it. You can also look at third parties, like your competitors. What are they pursuing? Are they registering IP rights? Where are they registering them? Which markets are of importance to your competitors and to you? And finally, what is the objective, commercial objective you're trying to achieve here? Are you trying to position yourself to enforce your IP rights against third parties? Is it a blocking mechanism, or is it a branding and trade strategy that you're looking at? So these are, there isn't a specific answer when you talk about a strategy for registration of IP, but these are all the typical considerations that you should go through when you're thinking about embarking on a filing strategy or filing exercise. So I've extracted some of the more common considerations. You talk about geographic, because IP is territorial. So you have to decide which markets or which specific jurisdictions you actually need to have your IP registered in. The issue of ownership is something that comes up, because if you own your IP, or is it co-owned, there are implications. In co-ownership, there are restrictions on how easy it is to license your IP to third parties, right? So sometimes IP is developed in collaboration between one or more parties. And down the line, when there are differences over commercialization, that's where co-ownership can become an issue. So this should actually be something that's considered at the onset. Understanding the IP landscape. So IP landscapes are a very broad term. There are many ways of looking at it. So one way is about what we call patents, right? Looking at the patent landscape and the density of patents in a particular technology in a market, for example. That gives you an idea of how many competitors there might be, who's interested in that particular area. So that can also lead to further questions of, are there more infringement risks because there are so many patents, like a ticket, right? Is it worth going into that area in this particular market? Should we focus elsewhere? This was what I talked about before, the technology lifespan versus the commercial lifespan of a product. If you, in the event, the commercial product actually has a shorter lifespan, then the money that's put into perhaps obtaining the IP rights, for example, a patent, could be wasted, right? Thrown away in that sense. So it's not necessary to always file for IP rights. Licensing in is an alternative where you don't have the IP. Perhaps licensing that IP may be an alternative. So the phrase of avoiding reinventing the wheel, right? You don't need to do it, just license it in. Perhaps it might be an easier way to achieve the same purpose. Funding and filing mechanisms. So that's of course very important. There are many government grants available in Singapore. For Singapore companies, you have Enterprise Singapore that does make a fair amount of grants available for various purposes. And one of them is, for example, the market MRA grant. It's a market readiness grant. From Singapore, if you're expanding into overseas markets, you can then utilize these grants to help buffer some of that cost. And that can be very helpful, right? Quality versus quantity. So it's not about how many you file, but rather getting intangibles in place that are going to contribute to your commercial objectives, right? Commercial objectives lead the way, and IP or intangible asset strategy is there to support your commercial strategy. And finally, we have the international filing mechanism. So there are various mechanisms such as the PCT for patents, the Madrid Protocol for trademarks, Hague Convention for design. So what these are, they don't give you the registered rights directly, but it's like an administrative mechanism through which it can facilitate the international filing. One application can facilitate getting IP rights in many jurisdictions concurrently. So these are some of the points that should be borne in mind when you're considering filing your IPRs. They help to save time and costs. So just the final topic for my talk about prosecution in Singapore. So Singapore itself, we have various mechanisms to facilitate a patent or IPR prosecution. One of them is for the domestic route. It's called the SG IP Fast Track. It's currently going to be available up to 30th April 2024. We are hoping that it will be extended, fingers crossed. It's complimentary, so no extra fees, and it's very straightforward because straightforward patents can be, under this scheme, can be granted in 6 months, non-straightforward ones in 9 months. So that's very fast for patents, right? For those who are familiar with the patent process. Straightforward trademark applications, apparently in 3 months, and those that are not straightforward in 6 months. So again, as far as the trademark process goes, that's really considered very fast. And design applications within 1 month. But then, of course, as with everything, there are several conditions to meet if you want to qualify for the scheme. Every month, there's a cap of 10 patent applications in total, right? So it's first come, first serve in that sense. And you have to also file what is called a search and examination request on the same day, let's say for a patent application. Because sometimes parties an applicant may want to file the application first, but defer the search and examination to a later period. And that way you can spread the costs out. But under this scheme, you have to do it on the same day, which means the upfront costs are going to be a lot more substantial. So you also have faster turnaround times expected of you. Normally, you have 5 months to respond to a patent office action. Under this scheme, you just have 2 months, right? So no extension of times are permitted, and your application has to have less than 20 or less claims. So once you file your patent application on this accelerated track, your design and trademark applications must also be filed within 12 months so that you can enjoy the acceleration process. If you file it outside, right, you then don't get to be on the scheme. A few other points for trademarks. You have to select them from a pre-approved list, which is quite comprehensive. So it's not really a downside necessarily, but unless you're using very specific goods and services, very niche services, then you may not fall within the pre-approved list. Right? We also have a patent prosecution highway. So that has 27 global offices under the global PPH, and IPOS also has several bilateral PPHs with China, Brazil, Mexico, Saudi Arabia, and the EPO. So how it works is the examination process in one IP office, right, can be accelerated by referencing the earlier results from another IP office. So this generally, even in my experience, it generally results in fewer office actions being issued and also therefore accelerates the grant of patent rights. So PPH is really a very useful tool, and Singapore has is really well connected, the IP office, in having both the global PPH as well as several bilateral PPHs. Finally, we have the ASEAN Patent Examination Cooperation, or ASPEC. So it's similar to the PPH, and essentially it covers the ASEAN patent offices. So it's a very similar model where the work product from one office can be used for another, and therefore accelerate the grant of a patent, but it's within ASEAN. So just in closing, the main points: intangible assets are growth drivers, but it's more than IP, right? And it's important to have an intangible asset strategy. Having an intangible asset audit helps you identify these intangibles, how they're being used, and the risks associated with them. Once you have done that, protection of your intangible assets is necessary, but then you have to be strategic in how you do it, what needs to be registered, what does not need to be registered, and how do we ensure maximum value. These are all points to be carefully considered before you embark on a filing exercise. But if you do, Singapore has several schemes that can help you accelerate the grant of your IPR if you qualify. So with that, I'll hand you back to Max. Thank you very much.
Thank you, Jevon, for that very enlightening and comprehensive coverage overview of the IP system, why companies should really seriously look into how they manage their IP, not just in Singapore, but around the world as well. I don't think that there are any specific questions for you at this point in time. Maybe we'll have some later on coming in. So I think with that, we can turn the floor over to Marta. Marta, the floor is yours. Thank you.
Thank you very much, Max. Thank you to the host for organizing the event, to my fellow colleague speakers, and to all of you for joining. I'm not gonna spend more time on who we are because Max already gave a nice and fair introduction of Fidinam and what we do, but I'm gonna jump straight to the immigration and HR topic that all our company needs to face and take care of when it comes to grow their business, especially in a jurisdiction where the open immigration policies has always been one of the key factors for the success of this economy, even if I would say that recently, especially in the post-pandemic era, Singapore has imposed a stricter controls on the inflow of the foreigners, foreign talents, in order to support the employment of his citizens first and to boost the citizen wages. I would say that it appears that the Singapore government is not merely reducing the number of foreigners entering the country, but rather introducing a different sort of criteria, which is to increase the quality of foreign talent in the country. Notwithstanding the government's effort in tightening this immigration policy, I would say that anyway, Singapore will still go beyond its border to look for experienced and qualified professionals to support the economic growth of the country. And how do you hire the right candidate once you have found it? Well, if it is a Singaporean or a permanent resident who are comparable to the Singaporean, then you don't need to care and think of apply for any kind of working visa. You have to consider that Singaporeans as well as a permanent resident can work in Singapore or for even more than one employee, so they do not need a sponsor, while foreigners need a valid working visa. And the employment pass is, I would say, the most common one, the one that we always hear people talking about, and it's mainly for high qualified individuals, for professionals who earn fixed salary of at least a monthly fixed salary of at least 5,000, 5,500 when it comes to financial sector Singapore dollar, and this salary is going to increase progressively with age up to 10.5, 11.5 for the financial sector K Singapore dollar for those people in their mid-40s and above. Important for the employment pass, there's no quota required. Why is it important? Because when we will go through the S-Pass and the work permit, we will have to consider that there's a quota limitation to apply for this pass. The employment pass usually is issued for the first time with a validity of 2 years and up to 3 years when it comes to renewal. Employment pass holder can apply for dependent pass or long-term visit pass for their family members. And this is something that is an opportunity also for the one holding the S-Pass. Pretty important when you decide to hire a foreign candidate is that you, of course, as a company, need to give a fair chances to everybody to apply for the same job. And this is why the company must post online the job advertisement on My Career Future job portal and leave it open for at least 14 days. Bear in mind that if there's any changes in the job description, let's say in the salary or in some other criteria for the candidate you're looking for, the clock is going to start again. There are, although for, I would say, practical use, although companies that are exempted from applying, from posting online the job advertisement. And especially this is when the company has less than 10 employees, the salary for the role that has to be filled in is at least 22,500 Singapore dollar or above. The role is just for a short-term period, let's say up to 1 month, or the role will be filled by a local transferee from another company of the group. Pretty important to consider are and take into consideration are the changes that affected the employment pass application starting 2023. So basically from 1st September 2023 for an application and for renewals expiring from 1st September 2024 to qualify for the employment pass application, basically the candidate needs to pass a two-stage eligibility framework compass. So what's going to happen is that there are two stages related. The first one to the qualifying salary. We just talked about the 5,000 Singapore dollar minimum salary and 5,500 when it comes to the financial sector minimum salary. That is a criteria that has to be met. If the candidate does not meet this criteria, no matter what, no matter if the second stage is passed by scoring 40 points, is not eligible to apply, the company is not eligible, the candidate is not eligible to be applied for the employment pass. So the second stage is basically past the so-called point-based complementary assessment framework compass, which was basically put in place to ensure more comprehensive evaluation of foreign talent. The company and the candidate both together, because basically it's based on criteria that are related to the individuals per se and the firm, needs to score 40 points across 4 foundational and 2 bonus criteria, which are salary, qualification, diversity, support for local employment, skill bonus, and strategic economic priorities bonus for the bonus criteria. Let me give you an example. So let's consider a small medium enterprise, a startup in the biomedical science sector, which basically employs 15 PMET. With PMET, we are referring to professional managers, executive and technician. And the candidate is a 35 years old operation manager earning 8,000 Singapore dollar. This is pretty important, 8,000 Singapore dollar, and holds a bachelor degree from a foreign university. This university is not part of the top tier list. You have to consider that the MOM has a list of top tier university that is published on the MOM website. And this is important as well because it's going to affect the point that you can score when you run your compass test. The candidate salary is in the 77th percentile compared to the local PMET salaries in this sector. What's going to happen is that the qualifying salary and the salary that the employee is going to earn is going to be benchmarked to the top 1/3 of the local PMET salary in the sector by age. So salary, well, the candidate's fixed monthly salary, which we said is 8,000 Singapore dollars, so for sure meets the qualifying criteria stage 1 that we just talked about, is within the 65th to less than 90 percentile compared to the local PMET salary for sector by age. And it means that it can score 10 points. Qualification. The candidate is holding a bachelor degree from a foreign university. This qualifying diploma the bachelor degree must be submitted to an agency within the list provided by the MOM, which is going to take care of the verification of the qualification, of the authenticity of the qualification. Let's say is accredited, is going to get 10 points. And since the company is a small company, is a startup which employs 15 employees, diversity and support for local employment are met by default by getting 10 points each, which means that the company scores 40 points. Compass is passed. This is basically one of the most common cases. Most applications will fall into this category, but please always bear in mind that if a company and the candidate together, they're going to pass the Compass, it doesn't mean that the candidate application is going to be successful. Is likely to be successful, but it's always based on the discretion of the MOM officer and the authority to evaluate each application case by case. Another case study is going to consider a organization working in the financial service sector. So for sure, the minimum qualifying salary that has to be earned by the candidate needs to be 5,500 Singapore dollar at least. Company has a local PMET share at 40th percentile of its sector, and the candidate is coming from a less represented nationality in the organization, which in this case forms 4% of the organization PMET employees. This is important because it's going to affect the diversity criteria. The candidate is a 35 years old management associate and is earning 9,500 Singapore dollars, so is above the qualifying salary, minimum qualifying salary, and holds a bachelor's degree from a top-tier university. The candidate's salary is at the 60th percentile compared to the local PMET salary in the sector. And this is why, in this case, the first foundational criteria, which is salary, is not met. So is going to score 0 points. However, the qualification, which is verified by the agency, is from a top-tier university, and the points are not 10, as in the case we were discussing before, but are 20 in this case. Diversity, we said that the candidate is coming from a less represented nationality in the organization, and since the shares basically is 4% of the organization of the PMET employees, so less than 5%, is going to get 20 points. Again, the company is employing local employee, and its shares of local employees is at the 40th percentile, which means that is able to score 10 points. In this case, the points are 50, and the Compass is passed even if the salary, which is one of the 4 foundational criteria, is not met and is not passed because it's not going to score point. But again, since the candidate is earning 9,500 Singapore dollar, the most important and first qualifying criteria, which is the salary, the minimum one, is met. So the candidate is going to be eligible and likely to be successful for his employment pass application. S-Pass is for mid-level skilled workers, which earn a fixed monthly salary that goes from 3,150 Singapore dollar and increase up to 4,650, of course, progressively with age. Also, in this case, if it is a financial sector, we will see that there are a higher salary is needed. There are criteria that are basically related to educational, professional experience, and company credential for the application to be successful. The S-Pass is issued with a validity usually of up to 2 years and is renewal. But in this case, the company must have quota, which means that the company has to have local employees, PR or Singaporean, employed, in order to be able to hire one SPAS. Usually just to give you an example, in the service sector, let's say if Fidinam wants to hire an SPAS, or wants to at least submit an SPAS application, needs to have at least 5 to 6 local employees, Singaporean or permanent resident, working within its team. The SPAS comes also with levy, so the company must pay a levy of 650 Singapore dollar and must subscribe, pay and maintain a medical insurance for the employee. Same as for the employment pass, an SPAS holder earning at least 6,000 Singapore dollar can apply for a dependent pass in Singapore for family member. The duration is tied to the one of the SPAS. Basically, the EP holder or the SPAS holder are the sponsor for their family member in order to be able to stay in the country. There were some changes, and there are going to be changes in the regulation for SPAS, which are affecting the salary. There was already an increase in 2023, and starting from 1st September 2024 for renewals, and for 1st September 2025 for new application, and again 2026 for renewals, there will be an increase in both the salary benchmark, the one related to the financial service, which you can see is anyway higher than the one related to all the other sectors. So 3,150 up to 3,300, and 3,650 up to at least 3,800 starting from 2025 for new application, 2026 for renewal. Again, from 1st September 2026, there's going to be an increase in the levy from 550 to 650 for SPAS employer. For, as I said, the employer who's hiring an SPAS must buy a medical insurance with a coverage of at least 60,000 Singapore dollar per year per SPAS. For policy with starting day before 1st of July 2023, the coverage would have been 15,000 Singapore dollar. Last but not least, the work permit. Work permit is usually for workers from approved country and region, and for workers employed in construction, manufacturing, or process or service sector. Usually the duration is up to 2 years, and also in this case it's mandatory to have quota, pay levy, and buy and maintain the medical insurance. But the most important difference is that there's no pass available for family member if you apply for a work permit. Work permit is the one that usually is applied also in the domestic sector. There are other kind and other type of work permit or working visa that can be applied, but this type of working visa can be applied by the individual directly, but do require usually, like the personalized employment pass or the entrepreneur pass, do require usually high earning, a high salary and high qualification. When you hire a new employee, of course, there's a cost which goes on top of the salary that you have to pay. And again, we have a difference between foreigners and Singaporean or PR. When it comes to foreigners, basically, there's no obligation for the employer nor for the employee to pay social contribution. Foreigner can contribute voluntarily to any pension fund they want, if it's private, or a CPF fund as well. But there's no obligation to contribute by law. Although the company must pay a skill development levy, which basically goes from 2 to 11.25 Singapore dollar per month per employee. When it comes to hiring Singaporean or permanent resident, then it's different. It's different because both the employer and the employee have to contribute CPF, have to contribute skill development levy, and the employee must contribute to the SHG funds, which may vary based on race and religion of the employee. The CPF are paid on ordinary wages, which is, to give you an example, the salary, and on additional wages, which can be bonus or unpaid, untaken leave paid. There's a ceiling in both the case. So the ordinary wage ceiling limit the amount of the ordinary wage that attract the CPF, and these 6,800 as of now, but we will see there are changes that are going to affect the ceiling of the CPF paid on the ordinary wages, while the amount of CPF contribution payable on the additional wage is kept at the yearly AW ceiling, which is 102,000 Singapore dollar minus the total of the ordinary wage subject to CPF for the year. The CPF are usually calculated, and the rate may vary based on citizenship, Singapore citizen or PR. And when it comes to PR, it's important to understand the status. So if it is the first, the second year, or the third year of PR, the age group, and the total wage of the calendar salary. Let's say, to give you an example, for an employee in his 40, the employer rate is 17%, while the employee rate is going to be 20% of the wage. CPF contribution are due by the end of the month, even though there's a sort of grace period which allow the company to file CPF till the 14th date of the following month. The amount of CPF that can be paid and contributed throughout a year, so the annual limit, is 37,740 Singapore dollar. As I said a few minutes ago, there's going to be changes. There's going to be changes which are going to affect the CPF ordinary wage ceiling up to the 1st January of 2026. So in 2024, we already said the new ceiling is 6,800. It used to be 6,000 before. In 2025 will be 7,400, and from 2026 onward will be 8,000. And this is why the reason why is to allow employee basically to contribute more to their CPF, and the same reason is going to basically help employees age above 50 to 70% to increase the contribution of CPF, because basically there's a slight increase in the rate that is going to be contributed by both the employer and the employee. When you hire a candidate, of course, you have to take care of two hire or terminate a candidate, two I would say action. The first one is when you hire a candidate to register with the CPF board. So basically you need to be able to contribute to CPF board on a monthly basis. When it comes to termination, especially if the candidate who is going to resign or be fired by the company, who's going to leave the company is a foreigner, well, then you have to notify IRS by filing a tax clearance at least 1 month before the employee's last day of employment or departure, as well as you have to notify CPF and contribute for the last payment of SDL if it is a foreigner. If it is a Singaporean or PR, you're not going to file tax clearance because they are allowed to stay in Singapore or work for other company, but you will have to notify the CPF board of the termination of the employment contract. I think that is important to note what is going to happen if your company employs senior citizen. This is something that usually or sometimes is not mentioned. But actually, if a company employs a senior employee, have to be able to offer a re-employment to those that are basically approaching the retirement age, which is 63 years old. What happens usually, and what should happen, is that the company and the employee take a seat and have a chat on the future of the employee, at least I would say 6 to 3 months before the employees approaching the retirement age. And it's pretty important for the company to be able to offer the employee either a re-employment. Usually the offer should cover 5 years of contract up to the maximum re-employment age, which is 68, although the company can also offer a term contract of at least 1 year, which is going to be renewed or can be renewed, provided that the senior employee is eligible, so is of course medically fit, have a satisfactory work performance, has served the employer for at least 2 years before turning to 63, and is a Singaporean citizen or Singaporean permanent resident. If the company is not able to offer a re-employment to the employee, then there are 2 ways. Either the company is able to find a second employer who can actually offer a job to the senior employee, or actually the company should pay an employment assistance payment, EAP, which is equivalent at least to 3.5 months salary, subject to a minimum of 6,250 to a maximum of 14,750, and offer also outplacement assistance while the employee find a alternative employment. Well, this is it. Thank you very much. Thank you, Max. Back to you.
Thank you, Marta, for that very enlightening and comprehensive discussion on retirement and hiring practices in Singapore. It's certainly a lot to take on. So I think we might have some questions for the speakers earlier on. Maybe one is a housekeeping issue at the moment. It's a question about whether the slides will be shared. And I think that the answer to that will be yes, slides are being shared afterwards. Another question that's being asked is, I'll just read it out to the audience. Questioner is asking, saying he's a student in international relations and curious to know if the trade agreement signed between the EU and Singapore has played a role in protecting IPs of European and Singaporean products. And the question is, will we see a convergence in IP standards? Thank you very much. I guess that's a question for Jevon. Would you like to be able to take that question?
Thanks, Max. So I think there are 2 parts to this question. So the first one being whether the EU free trade agreement with Singapore has played a role in protecting IPs. So as with not just the EU free trade agreement, but even with the earlier free trade agreements that Singapore has entered into, such as the US free trade agreement, it prescribed various minimum standards that both countries through the free trade agreement had to abide by. So by and large, by the time Singapore actually entered into the free trade agreement with the EU, its IP standards were already, I think it's safe to say that it already met the international standard of what is expected. So it wasn't really very difficult. There weren't very much changes after the, or rather to give effect to the EU free trade agreement once it came into force with Singapore, right? So those standards were already there. So therefore, it did go towards playing a role in protecting IP for both Singaporean and European products, because I think more on it's the access to markets for the products, and therefore you then tend to want to file in those jurisdictions, in those markets, to protect your products and goods and services that you are offering in the EU, in Europe, or conversely in Singapore. And the second part of the question, will we see a convergence in IP standards? I think there may not be a complete convergence, but I do see various aspects coming closer together, right? Like, for example, when you talk about software patents, right? There is a general approach across the different jurisdictions, whether it's the US, EU, Singapore, Australia, where software patents are evaluated in a certain way. it may not be identical, but there are certain similarities. Some would argue even sufficient similarities that some of it could be said to be almost the same, right? So we do see a convergence in certain IP standards in terms of how different jurisdictions are interpreting or enforcing some of these IP rights. Yeah.
Thank you. Thank you for that. And I hope that answers the question, that was posed by the attendee. I think that there was also a previous question that was asked, and if I may just try to paraphrase the question that was asked, and I think it was basically asking whether or not one could purchase a company in Singapore. I guess historically in some countries, you would buy what we call a shelf company, a ready-made company that you could just acquire off the shelf and then buy it and then quickly do business using that company as a form of business. And I think, Quentin, you have more or less answered that question that was posed. Yeah.
I'm happy to reiterate, maybe to explain a bit more in detail and for the larger audience, maybe.
Please.
So I would say, from my experience at Sleek, when we get requests for just like buying shelf company, I would say what we usually advise otherwise actually to set up a brand new company from scratch. The reason being that actually setting up a company even from abroad is actually, first thing, quite straightforward. It would take maybe up to 3 days in general to set up the company. So first thing, it's quite fast. And second thing, the reason some of the company will have, maybe other editions, they would have shelf company, maybe because like the fees maybe to set up a business make it quite lengthy, quite expensive potentially. But I would say in Singapore, it's not really the case anyway. So and third thing also is like to be very transparent, like I do not know, to be fair, is there any services provided by sales provider or by Accra directly to purchase this kind of shell company in the first place anyway. So for this kind of request, actually, it might be, and my advice would be that it's just actually easier to set up a company from scratch rather to look for one to be bought.
Thank you, Quentin, for that answer. I do agree. I think that the practice of acquiring and purchasing shelf companies is one in the past where it took a very, very long time to get companies set up, and therefore corporate secretarial service providers used to keep a bunch of companies that are what they call shell companies that are available for immediate use by someone wishing to get off the ground more quickly and can just buy that and use it straight away, changing the directors and so forth. But that's not the case anymore in Singapore. It's so quick and so fast in terms of how we can open a company in Singapore these days that the need for shelf companies has just fallen away. So that's the situation we have. There is another question about what are the specific requirements for setting up a fund management company in Singapore? I think this might be directed at you again, Quentin.
Yeah. Okay. So here I would say I would reply to the best of my knowledge, because I would say at Sleek, what we do is we set up the private limited company part, which then own the funds, but we do not help ourselves setting up the fund themselves, which is a part basically which will be handled directly with, I believe, MIS, which is the Monetary Authority of Singapore. So unfortunately, I would say don't know basically, and I rather not give I'd say vague or incorrect answer. What I can do though is that at the end of the call, maybe I can share even the list. Like we do recommend like one specific lawyer who specializes in MIS licenses and set up funding funds. So I can share with you maybe just typing as an answer the contact of the lawyer, and that person will be able to help. But definitely me at Sleek, I would say I don't have the right answer for now.
Thank you, Quentin. Thank you. Do any of the other speakers want to share any thoughts on this subject, if you want to?
Well, if I may add something, I agree with Quentin. It really depends on the kind of funds license that you are looking for, because there are also different requirements. So it's better to look into it. But like for some fund license, you require, by way of example, 2 executive directors with at least 5 years of experience, or in some cases also a CEO with 10 years of experience. So it really depends on the fund license that you are looking at. So it is most probably the best way to be sure, first of all, which is the kind of services that you are looking for, and then as Quentin said, like go deep in detail and understand which are the requirements.
Thank you, Marta. That's right. I mean, there are a number, to my knowledge, there are a number of lawyers and professional consultancy firms who do help and specialize in setting up of such funds, fund management companies and licensing requirements in Singapore. So yeah, definitely they would be best placed to help in such situations. Okay, let me see whether there are any other questions. There was a question about carbon credits, and again, the question was simply put up, what about carbon credits? And again, it may be outside the scope of our discussion, but if any of the speakers would like to discuss carbon credits, then please feel free.
I'll have a go at it, Max.
Okay, great. Thanks.
I mean, yes, I think it's the perspective that you're approaching the issue of carbon credits. So if you look at it as perhaps, your activities, very similar to your regulatory hurdles in a sense, if your carbon credits are something that generate from your activities, and therefore subsequently you can use those credits to get some economic benefit, whether it's offsets or whatever, so basically economic benefits from those activities that you're doing, then I think it's arguable that that can be an intangible asset, because in a way, others who are not in that space and are not able to generate those carbon credits to then get that economic benefit, they're a little bit more restricted on the access to those benefits. So if your activities are such that you're able to generate carbon credits and then use them, I think that could be considered as an intangible asset. It's similar to a regulatory hurdle where because of the unique business of the company, whether it's in pharmaceuticals, for example, where you have you have met certain standards, whether it's certain manufacturing standards, ISO accreditation, that allows you to do something. That's a regulatory hurdle that others would have to overcome in order to enter your business. So that's an intangible asset as well. So I see them as being similar in that sense.
Yes, thank you. And I wonder whether the ability for a company to be able to generate carbon credits, is that going to be a criteria, favorable criteria in terms of helping companies get more points under the Compass framework in terms of being able to hire certain individuals in Singapore that they might want to hire as well?
It's not just specified, but it could be under one of the bonus criteria, especially the one related to the company. Absolutely.
Yes. Thank you, Marta, for that. Marta, I also have another question for you. There are often situations where persons might come to us about obtaining a dependent pass or long-term visit pass for their partners or their spouses, but these partners may not be registered. They may not have their marriages registered. In other countries, they have concept of a common law partner or common law marriage, but that concept is not really found in Singapore. So how do they deal with this situation when, if in Singapore?
Okay, well, when it comes to employment pass holders, especially because they can apply for DP and long-term visit pass both for their family, it's important in the first case that basically the employment pass holder is legally married, although the legal spouse needs to be either recognized or be a de facto couple or in common laws spouse by their country of origin. So if their country of origin recognize that de facto couple or the If it is a common law suppose, then there's a way by providing specific documents like a sort of certification or certificate that it's a de facto couple to apply for dependent pass. If this, I would say, relationship is not even recognized in the country of origin, then it's a problem.
I see. Thank you. So it really all depends on what evidence they can provide to support their case.
Yeah.
Yeah. That's interesting. We do have another question now, Sean Ladd. As a UK marine company, we were looking at setting up a representative office in Singapore via Enterprise Singapore. For 2 years, fact finding only, no sales, no invoicing, no employees, etc. But after 2 years, our application was cancelled. We are unsure as to set up or not. Did you manage to get a question? I think this question is mainly meant for Quentin then. Would you like to have a go at trying to answer the question?
Maybe I'll try again. I'll try my best to answer. So, I mean, I would say representative office, so it's different than what I've been mentioning in the presentation, which is about private limited. So representative office is basically like an extension of the UK company in Singapore, but basically the law that are mostly applicable are actually UK law. It's not the same thing as a subsidiary, which would be a private limited company. So the 2 years fact finding. On this one, I think to be fair, it's quite hard to know. Only Enterprise Singapore will be able to assist. But in your case, like if you were to reset up a new company, I guess like going through representative office is not the right option, and maybe it would be easier to just set up a private limited company owned directly by the UK company as a subsidiary. But on your question, like I mean, why it was cancelled, I think only Enterprise Singapore can assist on that.
Right. Thank you. Thank you, Quentin. Marta, would you like to add anything to this question?
No, I would like just to clarify one point because maybe it's me not really understanding. So they already set up a representative office, or they were just looking to it because no says no, it wasn't. After 2 years, our application was cancelled. So it was already set up for the first time and then cancelled.
Yes, I think the question is not, I mean, the statement here is not very clear. It's not very clear whether it was already applied for and was the rep office already.
Oh, because it was already applied for and they got the renewal, because the representative office is usually can be applied for up to 3 years, but every year it must be renewed usually. If they got the first renewal and after the second year, they were not allowed to renew anymore, because actually Enterprise Singapore can tell you, okay, you got enough time to understand if you want to set up your business here or not, then I do agree with Quentin. I would suggest to probably set up a private limited company because they already apply. If they have not yet applied, then the representative office can go for 1 up to 3 years, and usually every year you have to renew it. So maybe you're going to get up to 3 years of activity. But in the end, you are back to square one. You have to decide if for you is like a good market Singapore to stay and then go for a branch, or for a PT Ltd, so for a subsidiary, as Quentin said.
That's right. Thanks for that, Marta. I mean, the option of setting up a rep office is limited. It's a limited option because you cannot keep a rep office forever. After a certain amount of time, you would have to make the decision whether to set up a proper private limited company or not in Singapore going forward. So I hope that answers your question, Sean. That ultimately the rep office option is only for a limited period, and you now need to decide whether to set up a proper company in Singapore or not. Yeah.
Sorry, Max, if I may, I saw that they said it was cancelled by Enterprise Singapore, and yes, renew every year, but not after 2 years. Then I would say I would not consider to apply again for rep office. I would straight go for one or the other two solution.
Yes, that's right. That's right. Okay. What other questions you have? Let's see. In terms of obtaining I have another question here myself. In terms of obtaining a local nominee director to be a resident director in Singapore, do we know, I mean, how difficult is that process? What kind of fees are usually involved? What can you shed some light on that?
Sure, just one. Yeah, I can. So in terms of like how difficult is it to find the right person, I would say majority of corporate secretary provider will be able to provide a nominee director service. So I would say I will obviously say it's not that complicated to find a company which will be able to offer the services. From a fee perspective, there will be quite a lot of difference. I mean, I can share from Sleek us, which are 1,500 Singapore dollar per year, provide a nominee director service. And the last thing, though, I would put is that depending on exactly on the requirement of the company, the fees can go up. Specifically, if you're a company which requires some kind of licenses, typically related to financial services, employment agency services, then you need to have director with certain qualifications. And obviously, there are less people which will be available for them to be nominated director with those qualifications, meaning the fees will not be the same in those situations. If you just set up like a consulting business and basically then, for example, no specific licenses requirements, well, then yeah, maybe starting from $1,500 per year. If there are additional criteria required for that person to have, for this local director to have, then the fee can go much higher, even 10K per year or more, depending on the qualification required.
Yes. Thank you for that, Quentin. Thank you. I think we have another question that may just have come in. Another question is here of local directors having hundreds of directorships, and there are some concerns in relation to money laundering issues. So how do we find a good one again?
Okay. Yes, good questions. How to that? So yes, so they are indeed director with multiple directorships. So starting from the kind of like top line from a regulatory point of view, there's no set limit by ACRA in terms of how many directorship one person can hold. Now indeed ACRA is potentially looking at restricting that, but we don't have much information yet, I would say, at least on our side at Sleek, about what figures they have in mind at the first thing. So actually the requirements and issues about director having too many directorship usually comes more from the banks, because banks are not really comfortable opening a bank account for a company whose director is also director of like 50 or 100 more companies. And because obviously then he increases the risk about that specific director. So regarding finding the good ones, I would say here also it's actually related to price, meaning like it's possible for them to pay for a nominee director, which will only be director for maybe 5 companies. But indeed, then like you won't, you'll be paying a much higher fee because that person can only be director for 5 different companies. So if you really want to make sure like your director has a very limited number of directorship, then that's possible, but it probably cost a bit more than someone who is director of maybe 20 or 30 different companies.
Yes. Ultimately, it becomes a question of pricing as well. How you can look for a very qualified director, but that person will not become cheap for the services they're being rendered, right, for that. So
yes, sorry, I may add is pricing sensitive matter, but it always remember that a director, it doesn't matter if it is an executive or a nominee director, as like Quentin said, as liability. And this is also pretty important because there are liability, can be regulatory liability and so on and so forth, but there are liability for the individual. So sometimes I guess that this is important to highlight because it goes also hands in hand with the pricing and everything.
That's right. That's right, Marta. Definitely. That's a good point. Thank you. I think one of the other questions I may have as well, for any of you on the panel is that, you know, we've all heard about how it can be quite easy to set up a company in Singapore, but some of the difficult pain points these days are in terms of opening up a bank account in Singapore. That's pretty difficult, I understand. Is this something that you have experience in, or you can help the attendees shed some light on this issue? What's the situation there?
Yeah, happy to take this one as well. I can help on this one. So I would say from our experience, so if you open a bank account with, like, I would say traditional banks, so meaning the big ones such as OCBC, DBS, UOB, or international banks based in, also offices in Singapore, typically like HSBC, Standard Chartered, those traditional banks. Usually from a timing point of view, like you're probably looking at 3 to 4 weeks at least to open a corporate bank account, or even more. And in terms of like criteria to open the bank account, it's only at the discretion of the bank. And most likely they will not, in our experience at least, they don't share much about what are the criteria they look for. So they will ask a lot of questions to fill, of course, the KYC requirements. But ultimately it's always a bank that makes the decision. The only advice I will have is always to be as much transparent as possible and to be patient, because indeed probably looking at least 3 to 4 weeks no matter what. Now regarding fintechs, so typically company like Aspire, Airwallex, TransferWise. So here the opening process will be faster, maybe up to a week, and everything will be done online. Compliance part also will be a bit more streamlined and might be less of a burden compared to more traditional corporate bank. But to keep in mind also that those bank accounts are more limited, meaning like it's mostly used basically to transfer money in and out, and maybe you get a credit card. If you were to need like a loan, if you were to need like a credit note, if you were to need more banking and advanced services, they would not be the right fit. So what we recommend to our clients here at Slick is that first thing, identify exactly their needs. Do they only need maybe like online banks, or they absolutely need a corporate bank, because it's not the same story to open a bank accounts in each of them. And second thing, in any cases, though, to remember, like ultimately the decision is always up to the banks. So the goal is more to try different options, at least to always be able to have a solution. And just to be patient and understand that unfortunately, like even if like actually COVID helped to put a lot of process online, we're still looking at corporate banks no matter what for at least 3 to 4 weeks before opening the corporate bank account.
Okay. Thank you for sharing in that space. So Marta, do you want to share anything else on this, or any other point?
Well, I do agree with Quentin again. It's not that easy, especially, but I guess it's not only Singapore. Nowadays, it's not easy in any jurisdiction to open bank account, especially when it comes to so-called traditional bank account. What I can tell you that recently, especially for a small company or newly incorporated company, which they are starting their operation, as Quentin said, the timeline to get the bank account open is quite long. It's 3-4 weeks, but even more, as I said. And most of the traditional banks we are dealing with are asking for nexus, are asking for at least a tenancy agreement, or at least one employee, if not, of course, the supporting documents to show the business activity and of the company. Some of them also require a sort of minimum investment, which could be quite high for a small newly incorporated company. The alternatives is to probably approach a fintech bank and work in parallel with the traditional bank. But I would say that the approach of the traditional bank is quite understandable, also considering what happened last year, and also considering the fact that Singapore, I would say, is trying to attract investment, high net worth individual investment, and also considering what also IRS is basically implementing out loud when it comes to substancy of the company, and especially to with reference to holding company, to give you an example. But yeah, I mean, I guess that is not only Singapore, I guess it's every jurisdiction now that face the issue with the bank account opening.
Yes, yes. Thank you for that as well. Finally, I guess, Jevon, do you have any more thoughts that you would like to share about how and whether, in terms of companies coming into Singapore from Europe, do you think that they should look at their IP protection first, or should they come and incorporate the company and get it set up first and then consider IP protection?
Thanks, Max. I think it really depends on a few points. So first of all, if they're an established company in Europe and they're looking to come to Singapore, I mean, you already have your IP. Some of it you may not be able to change in terms of, let's say, you have your patents and designs. If they're already filed and you're out of time for it, you wouldn't be able to file them in Singapore subsequently or anywhere else. So that's one issue. But in coming to Singapore as let's say, a fresh new company, I think one of the points that was raised by Quentin was the choice of name. So we've seen this a few times where clients have incorporated a company with a particular name, and then they get a letter from another party saying, hey, you're using my registered trademark, right? So sometimes considering doing a clearance search, that's something that we offer. Clearance search can be helpful to avoid some of these issues, because then the client starts to scramble to try and figure out, okay, what's the next name I need to come up with. But it also depends, because sometimes they've gone down a certain road, they've signed agreements under, has a particular entity, and so then they've got to do a name change, they've got to go and get those contracts redone or varied and so on. So that can lead to a fair bit of disruption. So the name is actually something to give a bit more thought. If it's a fresh name that you're coming in with, just do a clearance, and maybe that would have a little bit more of an easier startup path.
Thank you, Jevon. That's certainly food for thought. I think there are no further questions that I see from the floor. Any last thoughts? Otherwise, I'll turn it over back to Clemence on this issue. Thank you very much, all the speakers. Really appreciate your time this evening.
Thank you very much, Max. Thank you very much to all the speakers, to Slick, Fidinam, Jevon from the Southeast IP SME Helpdesk, and to Max from Gateway Law. I also wanted to thank the Irish Chamber of Commerce, Swiss Chamber of Commerce, and all other national business groups for sharing this event. And thank you to all attendees. I hope you enjoyed the discussion and you found the presentation relevant. We will send you the recording. I think you will have access to the recording of the event, and we will share as well the slide. But I wanted to share also, we will organize an event on the budget where we will delve deeper into the budget implication with experts, business leaders sharing insight, discussing economic policies, and understanding the financial landscape in Singapore. So please stay tuned. For those living in Singapore, yes, I look forward to seeing you soon. And if you need anything, please don't hesitate to reach out to us. Thank you very much. Bye-bye. Thank you.
Thank you, everybody. Thank you for your time.
Thanks. Bye-bye.
Bye-bye.